you entered a plea. That's not swearing. Nobody came before the court and swore on upon the record. So as I said to Angela a while ago, somebody could come back 100 years from now and say, well, Karl never swore in open court under oath of affirmation, before a jury, and that's what I want to do. I want to swear before open. I want to get into an open court. I don't want this to end on a piece of paper, because they could say, well, that judgment is void, because does Karl really exist? Is there a man really, Karl Lentz? Did he ever make a physical appearance in Alabama? We've never seen this man. He's in Virginia. Just because he sent paperwork doesn't prove that he really exists. He needs to appear in open court and swear under oath of affirmation. So it's basically the same thing with you. That's why I say to people, listen to Richard Cornsforth. His stuff is he drags on way too long.
It's just Cornforth, not Cornsforth. It's Cornforth.
No S? Okay. Yeah, I don't know.
No S.
Right. Yeah, that's a tough to find.
Well, this is basically the question. If I did the jurisdictional challenge in July of 2011, they basically sent back paperwork saying that we do have subject matter jurisdiction matter over you. Your paperwork is frivolous and they poo-pooed me right out with the letters, and then they basically sent me a letter that I owe them $20, not $2,300, but $20, and they were going to put it towards the tax. So when they arrested me on Monday, in order to get out of jail, those fines that were paid had to be paid up in Shawano. So it was a bail set at, I think it was $2,300.
Wow.
Yeah.
Well, like I said, you listen to my older videos. The older things I did on Angela's show was like 188 or 189, and I made it very simple. I said, whenever you go before an arraignment, all you do is say, may I have a pen or paper, and you just write, is there a claim before the court? See, because you can't speak in an arraignment. If you speak in an arraignment, the judge will say, he could throw the book at you because he'll say you stuck your tongue at him or you had an attitude. So I don't say anything to a man in a black robe because I don't recognize that he even exists. I just address the court. I write on top, I say, notice, is there any man making a claim before this court? Is there a claim before this court? Will this claim be verified in this court at this time? So like I said, they have to say that there is a claim before the court. They have to answer you. They have to say, yes, there is a claim, or yes, there is a man. If not, that's why you're always moving under the common law. Because if you answer a code, if they say, well, we picked you up under Section 30305, 57D6, how do you plead? So plead to what? That dribble? I have no idea what the hell you just said. Oh, well, let me tell you what it means. No. I didn't write that code. I can't be held. It's like I didn't write that contract. I don't know what you're reading. I don't know how you're interpreting it. That's not my words. Those are your words. Don't tell me what they mean. And like I explained earlier on this call, the public law in this country is written by Congress. It gets sealed, enrolled in a vault in the Library of Congress. Nobody looks at it. The only people that look at it are the people who write the code book. So the code is written by some Canadians. So if you're saying to me that I'm in violation of a code that some Canadians wrote, I'm like, what? This is silly. All I'm here is the answer to the law. And all the law is in this country is common law. And all the law in this country is, did I hurt a man? Is there a man or woman who's going to come forth with a claim that I caused them harm? Yes or no? That's this country. If you get tricked into going into France and answering under codes, well then, like I said, they just tricked you. Because like I said, your great-grandparents might not, like mine, didn't speak or read or write English. They didn't get tricked. When they went to court, they knew that there was a claim before the court, that they did wrong. And they answered to the wrong. And that was it. It was over in 5 minutes. It didn't go on for, like you said, 9 months and appeals. There was none of this nonsense, 40, 50, 60 years ago. None of this nonsense existed. It's just a way for lawyers to make money and to make a huge legal industry to give them something to do, some money to make. So like, the whole thing is, like I said, learn what a void judgment is. Say that nobody came into open, and don't let anybody tell you that there's any such thing as a statute of limitations, because statutes of limitations don't apply to man. Man is not bound by latches. They're bound because they're bound.
So you're basically saying I don't have just 30 days to file a claim.
That's ridiculous.
Basically what they did to me was they came and got me. They supposedly said that they had a warrant for this Shawano County and a warrant for Dodge County, but I never saw any of the warrants, and I know on firsthand that the one warrant for the county that I live in, which was for $300 from an attorney, which is a third-party debt collector, there was no signature or stamp from the judge. There was no judge's signature on it.
That's what I said to everybody, too. I said, when you ever look
almost like extortion. They basically paid the judgment of $2,300 and got me right out. I didn't even go in front of a judge or anything.
Okay, look at it this way. I'm suing the federal court for $1 gazillion, okay? They handed me 2 orders. One was like 7 pages long, one was 9 pages long. You know what I did? I didn't read them. Why? Why bother? Because it's all legalese. I don't speak legalese. So see, this is what I'm saying. You're reading all this stuff that they're writing back to you, and you're trying to figure it out. Me, I don't waste my time. To me, I'm just saying, is this common law? Yes or no? There's no order that could be handed down except from by a jury. So if I don't see a verdict from a jury, I don't see anything. So like I said, I'd laugh when these guys are sending me orders. I look at the last page just to see if the edge is actually signed by a man, and it's not. It's all rubber stamped. It's all stamped by the signature of the guy or the woman. But I don't bother reading this stuff in the middle because I'm not going to let it get me upset because it has nothing to do with me as the man. So to me, I say that, look, this is why we still have a common law country. Use it and just drag it over to the common law side. And like I said, when you have a claim, it's going to go above their complaint. So your claim is going to get heard first. So that's how it works in law. Whoever paperwork goes on last is the first thing heard in court. So they already have a complaint against you. Or they already got a warrant. They got whatever nonsense. Now you're going to come in and you're going to put a original claim. You're not going to file a counterclaim. You're not going to make a cross complaint. You're going to file an original claim and say, look, they're administrating my property without rights. They're trying to tell me what to do, and they have no right to do it. And they're going to say, well, we have a right under this code. No, you don't have rights under a code. You have a duty, obligation, or privileges under a code. You don't have rights. Only a man has rights. A code is not rights. A code is not law. So that's what I said, this is so simple, it's scary, and I hope people start to understand what I'm saying. That the government comes at you, they have no right to come after you. If you're a man, you have to establish that fact. Like I said, my lawsuit is so simple. I, a man, claim, I've been harmed, I have rights, and they're secured and protected by the Constitution. And there you go, and that's it. I'm done. And, I don't have to give him my name. How many cases do you see, like anonymous versus anonymous or John Doe versus John Doe? You don't have to give him your name if you don't want to. You just say, I'm a man. And then the jury will come down and the jury will decide the matter. You have the right to move any claim or any complaint or any case against you. When it's a criminal complaint, it's the Sixth Amendment. And when it's a civil complaint or civil claim, it's the Seventh Amendment. So everybody has the right to a trial by jury. So like I said, you have to like I said, when you listen to Cornsforth, he'll tell you that no attorney will appear on the other side. And Clayton Cherry was on Angela's show, and he said the same thing. And this is what I tell people 100 times. If you go Google New York State, there has not been a foreclosure in New York State in over 4 years now because Clayton Cherry and his group went before the New York Supreme Court, and they said that if any bank wants to try to foreclose on any more people in New York State, the attorneys are going to have to come forth under oath of affirmation in open court and swear that everything that the bank is saying is true. And every attorney is now going to be held liable for any false claims. If he can't prove it, and he's going to be disbarred, he's going to be held liable for damages. So that no attorney has brought forth a claim from a bank for foreclosure in New York State for like 3 or 4 years now. Because, once you folks start realizing an attorney can't speak in a common law court, they can't do it. They can't bring forth a claim. They can't say anything. Only the plaintiff can say anything. So you could just say the plaintiff never appeared. And rule number 1, in common law, the plaintiff must appear. The defendant doesn't have to appear, but the plaintiff must appear. No plaintiff appeared. Like I said, I don't know how much simpler it can make it. Like you said, you got to stop overthinking it. And that's what people are having a problem with. Like, they're actually reading what these courts are sending back to them. And it's like, no. Is this common law? This started going legalese. I always speak common law.
Well, like Rod Class says, you use their own laws against them.
That's what I said. That's what I say. I use their U.S. codes. I use that uscourts.gov website, and I use their own words against them. Exactly. That's exactly what I do.
Yeah. Yeah.
You know, like I said, right, like if that man Rod Class says there is no whatever anymore. It's like, you know what? That's your belief. You know, as far as I'm concerned, the U.S. government just made this website this year, you know, January 1st, and it clearly says that all federal courts are Article 3 courts. So, you know, okay, I'm going to hold them to it. So I'm going to put it before them and say, what does your website say? And they'll say, oh, we're all Article 3 courts. Yeah, what does your federal court website say? We're all Article 3 judges. Like if you go to the United States, if you go to a United States District Court website, it says that all the judges there are Article 3 judges. So I'm going to hold you to it. They're just going to try to drag you over to the administrative side. They're going to try to drag you to the citizens.
Yeah.
And you refuse to go. You're like, I'm not going. You know, but like I said, the whole problem with the people when they're saying they're not going is because they start talking to the man in the black robe instead of just writing it and putting it on paper. That way you didn't say to anybody in the court. You just write on the top, notice. That means you're noticing the whole entire world. Not judicial notice, not executive speedy notice, just the word notice. Just say notice. Is there any man in this court who's making a claim? It's almost like you could turn around and look in the gallery and say, he, forever speak, you know, speak now, forever hold your peace. Is there any man who's going to make a claim before me in this court? Yes or no?